Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottled Business Sense show. We are in Pacific time. I want to welcome all of our viewers back to the episode. We have an interesting employment episode today with our expert employment attorney, Mr. Bill Bernard. But before I bring him in, you can always go back to watch other episodes, previous episodes that we've aired in the past over the last 4.5 years. And you can find us on Facebook, Twitter, Google+, LinkedIn, and just search for Bottled Business Sense Show, or you can always go to our website at bottledbusinessshow.com and take a look at our whole host of 4.5 years, 5 years of previous episodes. And it's an interesting watch because I was kind of looking back the other day at how many videos we've actually done. We've done these for free. And it's a great resource. I go back frequently and listen to episodes when I have a question or just curious. Bill is a host of resources. I'm blessed to be his co-host here and to have some knowledge. So then when I do run into a situation or I have a friend run into a situation, I know where to point them to because I listen to Bill and he's great at what he does. So with that, before we start the episode, I'm going to welcome our co-host Bill Bernard to the episode. Welcome, Bill.
Hey, thanks, Rick, and thanks for the kind words. And I do want to mention I have a couple of calls backed up from some viewers who did give me phone calls last week. And I got tied up with a couple of matters here so I apologize. I will get back to you guys just as quickly as I can. And I do try to make an effort to answer the calls I get. We have a very, it's a continuing show, you might say, because it involves the workplace and sexual harassment and a hostile work environment, which is of great concern to the nation and all state laws, because it is more prevalent than ever in the workplace. And in California, they're very strict about this sort of thing. And I want you to kind of imagine a chart in front of you that says sexual harassment at the top, and then draw a line to the left and put under that line quid pro quo, and then draw a line down underneath it to the right and put hostile work environment. So sexual harassment can take the form of either quid pro quo sexual harassment or a hostile work environment. Today, we're going to talk about the more interesting one, which is a hostile work environment. Because if you have a quid pro quo, it goes something like this. Hey, if you have sex with me, I'll make sure you're promoted to vice president. So it's a quid pro quo. You give me this, I'll give you that. A hostile work environment is much more complicated because it involves several elements that the complainant must prove in order to show that the environment in which he or she is working is hostile, and it's hostile based on being sexually harassed. Because you can have a hostile work environment and not be illegal. How about a good example? You have an employer who's just well, let me just say it, an asshole. And this employer yells at you and screams at you all day and says you're incompetent and you can't do your job. Now, one of your premier alternatives is to go find another job, because there's nothing illegal about being rude, obnoxious, or being an asshole. However, where the hostile work environment becomes illegal is if it takes place because of prejudice against a certain class of people, or because of retaliation, because of something you've reported that's illegal, or because of sexual harassment. And we're going to deal today with the hostile work environment based on sexual harassment. And remember, hostile work environment, quid pro quo, they both come under sexual harassment. And again, hostile work environment can take place in other areas, but today we're talking about hostile work environment based only on sexual harassment. So now, having said all of that, let's talk about these elements. Now, I'm not going to get too legalese here with you, but I do want to tell you about the elements, the 6 elements that are required to prove sexual harassment based on a hostile work environment. Number 1, sexual conduct. Gee, what a unbelievable thing, huh? You need sexual conduct. Everybody's stumped by that one, right? The complainant claims that the communication was intended to be sexual based on the manner in which the parties communicated to one another and the context in which it was communicated. Okay? So the nature of the communication and the manner and context in which it was communicated. Let's take an example. And, this has to be proven in court, right? Or the employer decides to settle depending on how critical this sexual communication was. How do we know how critical it is? Based on the other elements I'm about to give you after this one. But let's just take this one, sexual conduct. So somebody's joking at a car dealership, a male and female employee, and the male employee says, "I'll take it in the brown," in front of a female employee. "I'll take it in the brown." The female employee, which seemed innocuous, the comment, which seemed innocuous based on the color of the car, can become offensive to that particular employee. But that's just the first element. So if we just are dealing with the first element, the context and nature, the manner in which it was said, that has to be examined by the court, by the jury, when it comes to trial, or by the HR department, Human Resources Department, when it evaluates whether these comments were sexual in nature. But they have to be evaluated with all of the other elements as well. So the first element is sexual conduct. What's the manner and the context and the nature of what was said and how it was said and why it was said? The number 2 element is the unwelcomeness of the conduct. This element focuses on how the victim responds to the sexual conduct. And when I say sexual conduct, which is element number 1, I also mean sexual commentary. So how does this person respond at the car dealership? Okay? The evidence becomes crucial in terms of what others observe who might be hanging around, or in written communication, such as emails, text, pictures that are sent. All of this may involve how the response of the victim, the alleged victim, is taken. And therefore, that will measure whether or not the response is an unwelcome response. So let's recap. You have the sexual comment or conduct and whether it is unwelcome or not. Let's say 2 employees are dating, and after they break up, any conduct after that is unwelcome. Well, it could be anything that you said to this person beforehand was perfectly welcome, but now because you broke up with him or her, Now they're ticked off at you, and all of a sudden the same comments become unwelcome. Have to be careful of that. Let's take element number 3, the most important one, severe or pervasive. Severe or pervasive conduct. The critical lesson here is that not every sexual joke or touch is unwelcome or clearly inappropriate in the workplace. The same is true for profanity. To be unlawful, and I'd write this down, to me, be unlawful. The alleged sexual conduct is examined in total to determine if all of the conduct considered together rises to the high bar set by state and federal laws. So, if the alleged sexual harassment boils down to one interaction, that conduct will only be unlawful if it is severe. One incident of date rape, for example, is severe, while one slap on the butt is not severe, may not be severe. So you see, it has to be a severe or pervasive, not both, severe or pervasive conduct. Pervasiveness looks at how often the conduct occurs. For example, one physical touching may not be severe enough on its own. Combined with daily comments, however, it may be pervasive. So you have a smack on the butt, and then you have consistent comments over time, or consistent smacks on the butt over time. It can be pervasive, or it can be severe. How severe it is going to be determined by the nature of the conduct. How pervasive it is going to be determined on how long it occurs over time, whatever it might be. But it only has to be severe or pervasive, not both. So, let's look at the fourth element, and that is it must be objectively offensive conduct. It must be offensive to a reasonable person in the victim's position. So when it's examined at trial, or by HR or by settlement attorneys, the conduct that you're describing, the conduct that we're going to say was sexual conduct, that was unwelcome, and that was severe or pervasive, number 4 has to also be objectively reasonable to a person in that victim's position. So if Mary Doe doesn't find the same conduct that Jane Doe finds objective, then it may not suffice, because maybe she thinks it was just innocuous. Maybe the rest of the jury thinks it's innocuous. So it must be objectively reasonable. Number 5, try to guess what this one is. If we had objectively reasonable, what would you think we have next, Rick?
Oh, inobjectively reasonable.
Or subjectively.
Subjectively, yeah.
Subjectively reasonable. So it must create a work environment that was, in fact, offensive to the victim. How do we describe this? Well, let's think about this. Let's say you're in a work environment where you smack a female on the butt 10 times in a month, and every month you do the same thing. What if there's a complaint made? Well, we might be able to say that it was sexual conduct, of course. We might be able to say, number 2, that it was unwelcome. We might be able to say it was pervasive conduct and maybe even severe conduct. And we certainly can say that it could be objectively reasonable, that someone else in that position may not like it. But was it number 5, subjectively reasonable? What if this gal says, boy, I just love you doing that? Now it's not subjectively unreasonable, right? In other words, it could have all of the other elements fulfilled, but if the particular person doesn't find it subjectively a problem, then all of a sudden, it negates number 5, subjective offensive conduct. But what other element does it negate, Rick? Well, element number 2, unwelcomeness, right? Because it's not unwelcome.
Right.
So that number 5 element, subjectively offensive conduct, is very critical because it also affects element number 2, unwelcomeness. And what's the 6th and final element? Alleged conduct that causes the employee damages. You must have damages. You can have every element of liability met, but if you don't have concrete objective damages, you're not going to win. What do I mean by that? It is not enough to be upset and have hurt feelings, but you must have actual monetary loss, such as missed work or treatment for emotional distress. If you seek damages for emotional distress, by the way, your other treatment for emotional distress, maybe you've had psychological treatment before, all of your privacy issues become exposed because the other side has the right to see whether or not that emotional distress was caused by other problems or, in fact, whatever was occurring in the workplace based on alleged sexual harassment. So let's recap this. Sexual harassment, we have quid pro quo, which we're not discussing today. And we have hostile work environment, which we are discussing today. Hostile work environment has 6 elements. You must have 1, sexual conduct. The complainant was intended, the communication was intended to be sexual in nature based on the manner, nature, and the context of what was said or done. Number 2, it must be unwelcome by the alleged victim. Number 3, it must be severe or pervasive. Severe enough or pervasive enough over time. Number 4, it must be objectively reasonable. Another person in that victim's position must find it to be offensive. Number 5, it must be subjectively unreasonable or offensive conduct. It must be offensive to another third party in the victim's position. And number 6, it must cause monetary damages based on emotional distress, missed work, doctor's bills, things of that nature. I hope employers and employees take this into account when watching this episode, and they understand how critical this is and how a need to have a follow-up investigation, to have documented and have HR be involved when any of these allegations occur.
Oh, excellent. Sounds to me that documentation is key in this any situation, especially and specifically in this type of situation. And I would imagine the best advice is not to get yourself in this situation.
Yes, well, that's true. You know, I had a client call the other day, actually not the other day, about 2 weeks ago. And they said to me, hey, we have this problem. We're partners in this business, and my partner here had an affair with the accountant in our workplace. And the partner who then had this affair decided to tell the spouse that he had the affair. Commend him for his honesty, but that caused all kinds of problems. And so what do you do in that situation? Well, you take the chance that this employee who needs to be gone now because of problems I won't get into, the employee needs to be gone because of the involvement of the spouses and their knowledge in the affair. Now, what do you do? Is the employee going to be angry and want to sue, or is the employee going to understand that it was a voluntary act and that there's no problem and that he or she can find another job? Well, that can lead to an expensive problem either way, because now you may have to give this employee an expensive compensation package, a severance package, to get he or she to leave. So even if you're not sued, you're spending company money on a severance package to satisfy this employee, not only in terms of what he or she was making, but to have to go out and make sure that employee is covered while he or she looks for a new job, and that may be difficult to find. So you run into all kind of problems when you do this kind of stuff.
Well,
so you're right, Rick. Stay out of it. Don't get involved in the first place. And if you do, please call a lawyer right away. Get a lawyer on. You should always have a lawyer, an employment lawyer on board in your business anyway, a business lawyer who also does employment law, which I profess to do, which I think is the best way to go. You might have a business question concerning your LLC. You might have an employment question because your LLC has now hired employees. So anyway, having said all of that, I hope somebody got something valuable out of this. And I hope you'll tune in for our next show. And Rick, maybe you can tell everybody where to find us.
Yeah, absolutely. Well, everyone, this is a very sensitive topic. Find yourself in a very sensitive situation like this. Just do the right thing and reach out to somebody like Bill, who's an expert that can help you and guide you in the right way. Previous episodes, you can always go to bottledbusinesssenseshow.com and search for any type of resource. Bill mentioned today that we didn't talk about quid pro quo, but if you go back to September 27th in 2016, we did an episode there where Bill explained quid pro quo versus hospital environment, sexual harassment. And so you can review that, kind of get a feel for what Bill alluded to early in the show. And then if you have any questions, please reach out to him. But you can always find us on Facebook, Twitter, Google+, LinkedIn, and just type in Bottled Business Sense Show, and you can find us anywhere on those social platforms. Or if you'd like, go ahead, Bill.
No, I was going to say, I might also say that this show is worth going into and maybe in part repeating a little bit because laws change, and also you want to keep up on important sections of California law that apply to one type of sexual harassment may not necessarily involve the same explanation for another type. Now, when you watch Quid Pro Quo episodes, you'll see some definitions there, I believe, and some interesting aspects of what that entails. But it certainly wouldn't hurt to watch both of them because you get a complete overview. And then if you have any questions or if something has maybe changed, you can find that out on your own or through your own attorney or by giving me a call.
Absolutely. In fact, what I'll do below this video where you find resources and how to get a hold of Bill, I'll also include the link to this episode, and hopefully you can find that beneficial as well. Okay. So anyway, with that, Bill, thank you very much for your thorough discussion here today. Reach out to Bill if you have any questions, and we'll see you in a couple of weeks for our next episode here on the Bottled Business Sense Show. So thanks for joining us today, and everyone have a great day and a prosperous week.
Take care, everybody. Be prosperous. Bye-bye.